Welcome back to another edition of Between Two FARS. I'm Warnicki Miller here once again with the illustrious Michael Mark and the wonderful Robert Tepfer to talk to you about all things procurement law. Right now we're doing a series on litigation in front of the Armed Services Board of Contract Appeals, the ASBCA. That's the forum that you go to if there is a contract administration dispute. We want to look today specifically at the first document that will be filed by your opposition. That's called the complaint. And we're going to have Bob and Michael talk a little bit about how you dissect this complaint and why it's important to pay close attention to what is alleged. What do we look at, guys? How do we pull this thing apart?
Well, I think the first thing you got to do, obviously, is read it and give it to your program people and your contracting people. And then we're going to have to figure out, okay, so what do we think about each of the allegations? And I think Bob has a very good methodology of doing that, parsing this thing down to the last syllable so that we can begin to identify what our case looks like and what their case looks like. And that involves, what do we have that supports or refutes anything in each allegation of the complaint? And you have to do that sentence by sentence.
Yeah, I like to turn it over. You give them not all your time, maybe about a third of your time to respond to each sentence. And I ask them, and I make certain that as many people I can get involved do it and have them have meetings, because once again, they're not going to agree on what they saw, but you want to find out early rather than later. And hopefully you did something similar with regard to the final decision. But they need to tie, they need to have a response. They need to have the individuals who have knowledge of it. This is all attorney work product because I don't want to create a roadmap for a document request later, and it should be marked accordingly. And then I want to have documents on each allegation with regard to what they refute and what they would say. Mm-hmm. And then I want to ultimately, after they have that meeting, or they come back and give me that information, I want to have another meeting where I discuss it and make certain that nobody else comes up with other documents, nobody else comes up with a different story or different dates to refute that. And then sentence by sentence, implicitly, I'm putting together the answer.
Mm-hmm.
Okay, so that's interesting. When you're talking about going through it line by line, it's not only what your witnesses will say and what documents we have to refute each claim. Are you also looking at discovery aspects?
Oh, yes, absolutely. Because, somebody will say, that's not what such and such said on that date. Well, guess what? Or there's a document that does that. I want that document. I'm going to look at it. Later, I'm going to go into discovery and I'm going to ask the interrogatories in the context of, appellate's paragraph 1, sentence 3, please explain the document dated whatever, and the sentence which states as follows, and provide who has knowledge, who was at that meeting, that kind of thing. I want to iron that out because what I'm really doing is I'm setting it up. There's a flow to the litigation. I have to have whatever documents also that relate to that. I have to have the people associated with it that participated in the discussions. And I want the universe, so later if anybody else shows up, they can't testify because they're going to spare that's the universe. And then subsequently, I'm going to call them as witnesses, whether or not they be adverse witnesses, to testify with regard to what they said, which was different. Okay, all of that's got to flow.
So it looks like when you're dissecting the complaint, you've got this sort of factual evidentiary component. But what about the legal component? When you're dissecting this complaint, what sort of things are you looking for in terms of, hey, what am I going to do with this particular claim? Is it viable for a motion to dismiss? Is there a jurisdictional matter? Is it ripe for summary judgment? Talk to us a little bit about how the lawyer looks at the complaint.
Well, in any case, particularly a big one that's going to go on for a lengthy period of time, you're trying to parse it down and make it smaller. You're trying to make it smaller by effectively reducing it if by motion for summary judgment. You may go in with 6 issues. You may only win on 2, but that's 2 issues you don't have to litigate. You're trying to also lay the groundwork for later requests for admissions. Okay, maybe you're using the request for admissions in that statement, but you're trying to make the case smaller and smaller as it gets down to being smaller and smaller, and they see what they do or don't have for a case. The parties routinely, after discovery, and they see how good the witnesses are on the other side, how good their own witnesses are, they may ultimately come to an agreement like, this is the risk factor, and we want to settle for this amount. Are you willing to roll the dice and go to a full hearing?
Mm-hmm. Yeah, and you look at the complaint, you know, does it state something that was in the contract? I mean, is this a remedy that they have? You know, if they're arguing, for instance, differing site conditions, yeah, there are different site conditions clauses, but if they allege the facts necessary to state a claim for a differing site condition, we ought to know that already from the claim that we already denied, but now we've got it in the complaint. So what have they said? You know, we may be able to file for dispositive motions because they failed to state a case that's viable, and we don't have to go through discovery. I'm not sure we're going to win on those things, but you know, my view is if you're filing motions like that, even if you lose, what have you lost? And the answer is nothing. So,
absolutely.
You know,
I'm a big believer in those kinds of motions because you're really doing discovery against the judge. Right. Because you're finding out if the judge comes back and say, I don't have sufficient facts in this area, guess what he's going to get a lot of? He's going to get a lot of discovery that speaks to that area, which he said was deficient. You know, it all kind of, it's really a wonderful experience to do one of these, from the standpoint of parceling it down and learning what you've got because your folks are not opening up on it, learning what they've got. You also have to learn as much as you can, consistent with the motion practice that you speak of. What's the judge going to demand? Is it going to be strict adherence to federal rules, or is it going to be very, very relaxed? That's going to tell you what you got for a case as well.
And that's a point also that, you know, once they assign a judge, you need to know who that judge is and what that judge's way of operating is. You know, what does a judge, you know, we know, does he like this? He doesn't like that. He likes to strictly adhere to the rules of evidence. He doesn't. You know, those are things that you can begin to factor in. And also that factors into the way you start filing your motions. If you're pitching towards things that we know from case law or from our knowledge of that judge, that these are things he doesn't like, then we've got a better chance. So you want to play to the judge to some extent. I mean, you've got a case, you've got to deal with it, but you've also got a judge. And, you know, one of the things that Ralph Nash, some attorney that taught both Bob and I things way back in the past, he said, you want to make the judge cry. If you can make the judge cry, you'll win your case. So, you know, if I can make the judge cry or at least sob a little bit, then I'm helping my case.
Yeah,
and there you go. You get started with making the judge cry by understanding your complaint, properly dissecting it, and formulating your game plan. We've got lots more to talk about with ASBCA litigation. So join us again next time between two FARS.